I've been asked a number of questions by students of law and students of business. But the main question that they've been asking me about is how to approach legal exams. And today I want to share with my students about how to answer legal questions. I'm going to take you through a simple guide on how to approach legal exams. It's very important for you to answer legal questions well. It's very important. So, what I'm going to talk to you about is a guide which will teach law and business students how to answer essay type questions and scenario problem questions. I know the process of becoming a lawyer or business person is not easy. It comes with such problematic exams. Truth be told, law exams are technical. They are very technical. They are not a walkover. You find that they are full of challenges. Sometimes the statements are so wide. Sometimes the problem question is so big and students find it so hard to apprehend the questions. But I believe in today's lecture, you'll be able to appreciate, you'll be able to understand how one can make an attempt of a legal question. So the reason for this talk is to equip law students on the basic tips that will act as a guide when doing law exams. So below is the brief content of what we intend to talk about. We are going to address ourselves to two basic type of questions. Number one, we are going to address ourselves to essay type of questions. Questions which are in essay form. And number two, we are going to address ourselves on problem type of questions. Now, let me begin with our number one, essay type of questions. It's very important. Listen to me very well because I want you to get this properly. I'm talking to my business and legal scholars. Essay type of questions are questions that require the candidates to explain, discuss, or comment on specific legal issues as asked by the examiner. These are questions which look for specific legal issues. For example, discuss the sources of law in Uganda. Now, when you interface with such a question, it's a discussion question, but it limits you to sources of law in Uganda. So it is specific to a particular legal topic. And the legal topic in this question is sources of law in Uganda. So basically, you are not supposed to deviate from what the question is asking. Limit yourself to that source of law and discuss it. Question number two, discuss the characteristics of an incorporated company under the Companies Act 2012. The question is limiting you to characteristics of an incorporated company, a registered company under the Companies Act. So you limit yourself to the outcomes of an incorporated company, nothing else. Those are the ones which you're supposed to this business scholar. So basically, those are what we refer to as essay type of questions. Now, how do you approach such questions? How do you approach such questions? And I am saying that in answering essay type questions, the student will be required to write an essay. You'll be required to write an essay. And an essay consists of three major parts. An essay consists of three major parts. So basically, when you are writing an essay with such questions that I've talked about, how do you come up with it? And I'm saying that such an essay should have three parts. When you're answering an essay type of question, it should be in three parts. Part number one is the introduction. It is important for you to have an introduction when you are answering an essay type of question. And I'm saying that to answer an essay question, one must know what the question is about. You cannot answer what you don't know. Why? Because essay type of questions limit you to a particular subject, limit you to a particular document. And what that literally means is that there is no gambling when it comes to an essay type of question. You can only answer it when you know the subject that it is asking. That is why I'm saying that you need to know what the question is talking about. And you get to tell that to the examiner through your introduction. Very important. The introduction shows the examiner how you are going to tackle the question. Show him what, how, and where you will focus when responding to the question at hand. Take him through how you are going to answer the question. That is what I'm talking about. The way one molds an introduction tells the examiner if you understood the question or not. How you mold your introduction. Because an introduction is the gate into the subject matter of the question. An introduction is an eye-opener to the examiner. That is why your introduction needs to be thorough when you're answering a legal question. Very thorough. You need to be very thorough. Very thorough. An introduction must be well arranged. Number your points, make them visible, be clear in your explanation, and be neat. Be neat. Even in introductions, you need to be clear. You need to be clear when you are dealing with a particular subject. You need to be clear. Because how you package the introduction shows the examiner whether you understood the question or not. Make your points visible. Be clear in your explanation and be neat. Examiners have a lot of papers to mark. They have a lot of papers to mark. Because you may find that an examiner has over 100 papers to mark. So when you create a difference from the others, then the examiner will get keen interest in your work. And the moment the examiner gets attracted to your work, then you are going to get good marks because your work is distinct from the others. And remember to keep it simple and straight. Keep it simple. You do not have to wonder about we have a body in an essay type of question. And the body is basically a discussion of that particular subject that the question has pointed you to. For example, in the question of discuss the sources of law in Uganda, the question has pointed you to sources of law in Uganda. So in the subject matter or in the body, that is where the person is supposed to put focus. That is where a student is supposed to put focus. That you address that subject matter, you address the sources of law, you answer the sources of law in a discussion form. Discuss the various sources of law to the examiner. Very important. Without any deviations. A discussion is like you being in a group setting. It's like you having gathered data, having gathered literature on a particular subject, and you are given fora to discuss it. So that is how you're supposed to answer a discussion question. That is how you're supposed to answer an essay type of question. It's very important for you to discuss. That is why you need to have a beginning, you need to have a discussion, and you need to have a conclusion. And you're supposed to be simple and precise. When you are discussing a question, when you're discussing the body, make sure that you are appealing to the examiner. Make sure that you own up the discussion. Make sure that you take the examiner through the discussion. Enlighten him on the sources of law in Uganda. Because he has put himself in a position of, I don't know. And now that I don't know, please go ahead and discuss for me the various sources of law in Uganda. So, teach the examiner through explanations about the different sources of law in Uganda. That is what we mean by an essay type of question. Number 3, an essay type of question should have a conclusion. Since you began with an introduction, it is important for you to have a body discussing all the points. And then you need to have what we call a conclusionary note. Never begin a journey without an end. Because when you begin a journey without an end, that means that you'll never reach. That is why it is important to have a conclusion when you're answering an essay type of question in a legal exam. It is important to have a conclusion on every asked question. And a conclusion is basically a summary of the points that you talked about in the body, of the points that you discussed, and a conclusionary note from you as the student discussing your position and your final remark in regard to the question. So in summary, that is how essay type of questions are answered in the legal exam. Number 2, we have what I called problem scenario questions. Problem scenario questions. And these are usually a problem to scholars find these questions so hard. But at the end of this talk, I have all reasonable belief that you'll be able to apprehend, you'll be able to understand how to answer problem questions. Now, problem questions are types of questions that are answered in the formula that I'm going to talk about. They're answered in the formula that I'm going to talk about. And these type of questions involve a summary of facts. When you are given this type of problem questions, as a business or legal scholar, it is important for you to come up with what we call brief facts. You come up with brief facts. State the material facts of the scenario given. If the scenario is too long, and for the purpose of time, you may skip this part and move to the next step. Sometimes you find that the scenario is too long and you do not have enough time to summarize the facts. So if you find that it is too long, you may not necessarily summarize the facts. But it is also important to summarize the facts. Because when you summarize the facts, that summary is what we call a brief of that bigger problem question. A summary of important facts that arise out of the problem questions. Now, after coming up with the summary facts, you go to the next step. And the next step is referred to as you raising issues. You raise legal issues out of the facts that you summarized, or out of the facts. You raise issues, and issues are usually in question form. Issues are usually in question form. Whether there is a contract, whether the parties can enter into a contract, whether there is a justifiable cause, what are the remedies available. That is how issues are raised. Because when you raise issues, it is those same issues which you are going to resolve. Now, number 3, when we are addressing problem questions, is that you state the laws applicable. What are the different laws that particular problem addresses? It is important for you as a legal scholar to state the different laws which that particular problem question talks about. It may be the Companies Act. It may be the Contracts Act. It may be the Public Procurement and Disposal of Public Assets Act. It may be the Copyrights Act. So you state them, because that is where you are going to get the laws which will help you resolve the issues that you started. And as you are stating the different laws that you are going to base on, and by laws I'm talking about statutes, written laws. It is also important for you to state what we call precedents or case laws that you intend to rely on. For example, under the law of contract, you will be forced to rely on Khalil versus Kabolic Smoke Ball Company. And that is a case is a particular subject that has tested a particular section of the law, of laws. Decided matters of law are sources of law. That is why we rely on them when we are resolving issues in problem questions. Let me say it again as I'm finishing up with the problem questions. Number 1, when you're answering a problem question, You need to come up with a summary of facts, what I refer to as brief facts. After coming up with a summary of facts, you raise issues, and issues are usually in question form. And after raising the issues, you state the different laws that you are going to rely on, or which that problem question addresses. And after raising the different laws and probably the sections of the law that you intend to rely on, you also talk about some cases that you intend to rely on when you're discussing the issues. And lastly is what we call a resolution of the issues. Resolution of the issues is the body. Resolution of the issues. That is what we mean by discussing the issues together with the laws that you talked about and the cases you quoted. You begin answering the issues you arose, or the issues you rose, by quoting laws and decided cases. Quoting laws and decided cases. Note, it is important for you to note that it is in the resolution where, as a student, you bring in your arguments and application of the law to the facts. This is where a student begins to resolve the questions based on the issues, laws, and cases. You get to own up the question. You get to explain to the examiner what the issue arose is all about. You address the examiner. Remember, this issue came from the problem question. And after resolution of the issues, you'll come up with a conclusion. And like I said, every beginning must have an end. You'll have a summary of the points you discussed in your resolutions, and then a personal opinion on the subject that was asked by the examiner. I am persuaded to believe that you found this talk helpful. Don't hesitate to share this with any other business or legal scholar, because this is a problem which has been persistent, but I believe that you've got the keys to answering legal questions. Subscribe, ring that bell, so that every time I send a video, you'll be able to receive it. Be blessed. It is always a joy to talk to you, my students. Have a success story in your exams. You'll thank me one day. Be blessed.